Welcome to another episode of Travel Talks presented by Outer Temple Chambers. Today we're looking at limitation in the Czech Republic, Denmark and Poland. I'm very pleased to be joined by three speakers from those countries, and I'll ask each one to introduce themselves. So first, if I can start with you, Klára.
Hello, everybody. I'm a speaker from the Czech Republic, from a law firm Holubová, which has a seat in Prague, in the capital of the Czech Republic. And I'm a partner in Holubová Advokater. I'm specialized in travel business law advisory, and then, of course, in personal injury. This is why I'm joining the panel.
And Gabriela, would you like to introduce yourself?
Thank you, Ian. Thank you for having me. My name is Gabriela Lenarczyk. I work at Budzowska Fiutowski Partners in Krakow, Poland. We specialize in medical negligence and product liability cases, and we often have a chance to cooperate with British lawyers as well. So I'm very pleased to be here today.
And last but certainly not least, Kira.
Thank you, and thank you for having me. My name is Kira Kolby Christensen. I work with Elmer lawyers. We are specialized in personal injury and with any aspect of personal injury, so both traffic accidents, medical accidents, and also product liability and any other personal injury. And this is why I'm joining today, discussing also limitation periods.
And of course, all three members of the panel are members of POPL, the personal injury organisation in Europe. And today we're focusing in on limitation periods, which is cross-border cases which are being run in England, but applying foreign law is one of the most important questions, in fact, one of the most pivotal questions that need to be known. And what I'd like to start off with is discussing the limitation periods in personal injury claims. First of all, Kira, how long is a limitation period for a personal injury claim in Denmark?
The usual period is 3 years, and it runs from the time of the incident or from the time where you were supposed to be aware of the damages you've suffered from the incident. So it may sort of be suspended if you're not aware of you have any injuries. For instance, if it's disease that is long coming, it is from the time that you are aware, that should be aware that you have permanent personal injury. So usually 3 years.
And does that 3-year period ever change depending upon the type of personal injury accident that involves, whether it be a motor accident or maybe an injury at the workplace, or does it always tend to be 3 years?
It's usually 3 years, but for occupational industrial injuries, it will be 5 years and running also from the same time. So it's from the time of the incident or from the time where you were supposed to be aware of your injuries. In occupational disease and occupational injuries as such, there is also a special process where you have to make a report to the labor market agency, and they look into the matter, and then might say the limitation period is suspended during the time which the case is under process, but is only for the claims that are related to permanent injuries. So permanent injury or permanent loss of earning capacity, they are suspended during the process.
Thank you. And Klára, what is the position in the Czech Republic? How long is limitation?
The magical number for the Czech Republic is 3 years, so the same as in Denmark. And it also runs from the moment when the injured party became aware or could have become aware of the damage, and also the person liable for it.
And is there any variation on that 3-year period with regards to the cause of action or the mechanism by which the person was injured?
Not at all. In Czech, for example, we do not distinguish for this purpose between torts, contracts, or other breaches. So it would be all the same. It would be mainly established on a Czech civil code. So I think that if you remember number 3, you will be correct.
Wonderful. And Gabriela, is it 3 years in Poland or is it different?
Yes, 3 years as well. Although there are 2 prerequisites to that time limit. So you have to it starts running from the day on which the victim learned of the damage, but also of the person obliged to redress it. Or on the day, it starts running on the day when the victim could have obtained that knowledge had she or he exercised due diligence. There is no upper limit here. That's what's interesting in Poland. So a misdiagnosis could have occurred 10 years ago, but if you only learned about it today, you still have 3 years to pursue your claim. Although there is one complication here, this special provision, because this limitation period regards only personal injuries, this came into force in 2007, and it only applies to cases which were not yet time barred in 2007. Before, it was only 10 years maximum.
Now, you've all spoken about situations where somebody might not realise that they have sustained an injury, and clinical negligence and some workplace type accidents can be common examples of those. Gabriela, you were saying about reasonable diligence. Have the Polish court set tests to assess what would be reasonable diligence, to distinguish that from somebody who maybe has just been a bit lazy?
I think each case is treated individually by the court. So it's a matter of good preparation of evidence. When it comes to finding the person liable to redress the damage, we are very careful with that. We always reach out to the hospitals to find out who their insurer was, or to medical practitioners, so that we always have that letter in evidence, and we can prove to the court that we've done and our client has done everything in their power to find out who was responsible for the damage. Sometimes the hospitals do not respond at all, and we are not aware of who their insurer was up until the court proceedings start. And
are there similar principles in the Czech Republic, Klára, with regards to that issue?
Knowledge is something what I could also apply to the Czech Republic, and in general, I would say that it is important that the client is really not waiting for getting exact numbers. It happened to me that the clients were thinking that as long as they don't have the exact number of damages, then they can't time bar it. But this is not true at all. The important thing is, of course, only the fact that there is some damage, and the fact that there is some, or not some, but a specific liable person. So if these two conditions are met, the clock starts ticking. But in the Czech Republic, there is also another tricky issue, which is the consolidation of the health state. For many claims in personal injury cases, the clocks start ticking only at the moment when the health state of the injured is consolidated. Because at that time also, this is only the time when you can basically send the injured party to the medical expert for the assessment. So it's another tricky issue.
Okay, which just goes to show the importance of going to the right lawyer to be able to address these issues. And just one other thing with the limitation periods, is it 3 years, Kira, from the date of the accident, or is it rounded up to the end of the calendar year, as I'm aware that some countries do?
No, it's the date of the incident, so it's very clear cut. And also in regards to when you are supposed to be aware of your claim, the practice in Denmark is that if you have any medical documents showing or in any way revealing that you might have any permanent damages or any claims due to an accident, you need to come forward with them and start, because then the limitation period starts.
Okay. Gabriela, are there any special rules when it comes to children or those who may not have capacity to litigate? For example, somebody with reduced mental capacity.
There is one exception regarding minors. The limitation period of a claim of a minor cannot terminate earlier than after the lapse of 2 years from the day on which the person became adult. I should maybe mention another exception, because we have an exception regarding crimes. So if the damage resulted from a crime, then the limitation period is 20 years. But then again, this has to be established by the court, and there are not always criminal proceedings. So you really need to consult your lawyer if you think that an incident might have been a criminal offense.
So would that perhaps cover a case of an assault or a sexual assault or something like that?
Yes, definitely. It's just a matter of if the criminal court actually establishes that a crime has happened. If there are no criminal proceedings, then the civil court can consider that issue. But this, again, complicates the evidentiary part of the process for the claimant. It's not as easy.
And Klára, any special rules for children or those without capacity in the Czech Republic?
I could underline what Gabriela said. The rule is very similar, but in practice, I have to say that we usually don't wait for the kids becoming adults. Usually, we bring the claim, we make claims through parents and through the court, which means that if the kid is represented by a parent, then the parent is the representative of the kid. And we make a claim through the parent. In this situation, we have to have a special consent of the court, but this is how it's usually done.
Are there any special rules for people without mental capacity?
Without mental capacity,
Yes.
It would be the same. Those people usually also have a similar representative as kids have their parents. So people without mental capacity or with limited mental capacity, they also do have their representative for this purpose. So in this case, we are filing this action in the representation of this special person who is caring of the person with lack of capacity.
And what's the situation in Denmark, Kira? Any special rules for children?
No, not as such. When it comes to personal injury, it's 3 years, and like Klára said, we also have the parent as the representative of the child. So there is not as such any special protection of children in this regard. However, if the claim is based on any violation of the child due to sexual abuse or violence from the parents or the caretaker, there is no limitation period. It's a new regulation that came into force a few years back, sort of protecting those who have suffered such violations that they are not able to make their claim until they are adults. Usually they don't understand or recognize the damage they have suffered until they are much older. So we just said there is no limitation period. But for all of the claims, it's the same as for everyone else.
And is that the same with people who may not have mental capacity as well?
Yes.
Okay. Thank you very much. Well, that wraps up this episode of our Temple Travel Talks. We will be back again to look at extension of limitation and commencement of proceedings and what happens when limitation periods are missed in the next episode. Thank you very much, everybody.